This is my third session on solutions to the problem of our government overreach. I wanted to discuss a remedy which is seldom mentioned and almost no one today knows about it. This is the principle of interposition, otherwise known in our form of government as nullification. I briefly touched on the principle of interposition in a previous segment. To review, it is a principle that gives the lower magistrate the right and the duty to intercede for the people under his authority against a higher magistrate that is acting tyrannical or overstepping his bounds of authority. After the Protestant Reformation, Romans 13 was generally considered a personal mandate for obedience to government that didn't apply to those lower magistrates who had the responsibility to protect the people. The first precise explanation of this principle can be found in the Magdeburg Confession of 1550. So how does this principle apply in our form of government? Well, the founders incorporated this principle in our system of federalism, wherein the separate government entities, national, state, and local, were each given authority over certain aspects of governance. The founders' principle was that if one of those entities overstepped its bounds, the others would and should intervene or resist the offending entity, not allowing that overreach. In the early days of our republic, the states used a principle they called nullification to check the national government when they believed they had to overstep their authority and violated the Constitution. First, let me define nullification. Nullification can be defined as an act or set of actions that result in a particular law being rendered null, void, or even just unenforceable within a particular area. First, what nullification is not. When a state passes a resolution denouncing a particular federal law, it is not nullifying that law on its own. Or when a state or local government passes a law refusing to comply with a federal act, they haven't nullified that law yet. It is less about the legislation and more about the results. When several states pass resolutions denouncing a federal act, swaying public opinion so strongly that the federal government simply stops enforcing the law, it has been nullified. Or when local governments around the country pass ordinances refusing to assist the feds in enforcing a federal act, and the feds don't have the resources to enforce it, the law has been rendered null and void in practice. Now that we know what it is, what is the principle behind nullification? The main principle the founders expressed almost universally was that any law or act that violated the Constitution was null and void, by definition, unlawful. Hamilton contended in Federalist 78 that there is no position which depends on clearer principles than that every act of a delegated authority contrary to the tenor of the commission under which it is exercised is void. No legislative act, therefore contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than its principal, that the servant is above his master, that the representative of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. The real question then becomes, who decides what is a violation of the Constitution? Today, most people think that it is the job of the federal courts, specifically the Supreme Court. However, the principle of nullification denies that the courts are the final arbiter of all things constitutional. Why and on what grounds? We have to understand that the states were originally considered sovereign entities at the formation of the Constitution. They maintain their sovereignty under the Constitution, have delegated just a few of their powers to the national government. As sovereign entities, they made a compact with the national government and each other by forming the Constitution. I've already discussed this idea of state sovereignty in our national compact in a previous session. When there is a dispute between two parties in a compact, is one party given the power to decide the dispute over the other? Absolutely not. One party is never given the exclusive right to settle disputes between the parties. Otherwise, the parties would not be on an equal footing. Since the federal courts are themselves a branch of the federal government, how can the people be expected to consider them impartial arbiters? Here are a couple of quotes to get the flavor of this argument. This is from Spencer Roane, a Virginia judge in the early 1800s. He said, "I do humbly conceive that the states never could have committed an act of such egregious folly as to allow that their umpires should be altogether appointed and paid by the other party. The Supreme Court may be a perfectly impartial tribunal to decide between two states, but cannot be considered in that point of view when the contest lies between the United States and one of its members. The Supreme Court is but a department of the general government. A department is not competent to do that to which the whole government is inadequate. They cannot do it unless we tread underfoot the principle which forbids a party to decide its own case." Joseph Desha, governor of Kentucky, expressed the same sentiment in 1825. He said, "In fact, most of the encroachments made by the general government flow through the Supreme Court itself, the very tribunal which claims to be the final arbiter of all such disputes. What chance for justice have the states when the usurpers of their rights are made their judges?" These same principles were the basis of both the Virginia and Kentucky resolutions. In the Virginia Resolution of 1798, Madison wrote that this assembly doth explicitly and peremptorily declare that it views the power of the federal government as resulting from the compact to which the states are parties, as limited by the plain sense and intentions of the instrument constituting the compact, as no further valid than they are authorized by the grants enumerated in that compact, and that, in the case of a deliberated, palpable, and dangerous exercise of their power, not granted by the said compact, the states who are parties thereto have the right and are in duty bound to interpose for arresting the progress of the evil, and for maintaining within the respective limits the authorities, rights, and liberties appertaining to them." Similarly, the Kentucky Resolution of 1799 echoed Jefferson's sentiments from his draft of the Kentucky Resolution of 1798. He said that the principles in construction contended for by the sundry of the state legislatures, that the general government is the exclusive judge of the extent of the powers delegated to it, stop nothing short of despotism, since the discretion of those who administer the government and not the Constitution would be the measure of their powers. That the several states who form that instrument, being sovereign and independent, have the unquestionable right to judge of its infraction, and that a nullification by those sovereignties of all unauthorized acts done under the color of that instrument is the rightful remedy. Both those resolutions are not given much credence today, supposedly because none of the other states joined with them. However, a closer look at history shows that most of the other states agreed with the principle of nullification, but they just didn't agree with the specifics that the Constitution was violated by the Alien and Sedition Acts which prompted them. A couple of examples. In 1809, Connecticut Governor Jonathan Trumbull said in his speech to the state legislature concerning the federal embargo of the day, "Whenever our national legislature is led to overleap the prescribed bounds of their constitutional powers on the state legislatures in great emergencies, devolves the arduous task. It is their right, becomes their duty, to interpose their protecting shield between the right and liberty of the people and the assumed power of the general government." The Connecticut General Assembly then followed up with a resolution of their own, which restrained state officers from enforcing the federal law. Similarly, in 1858, the Wisconsin State Supreme Court declared the Fugitive Slave Act of the federal government to be unconstitutional and therefore void, and released a man charged with aiding escaped slaves. The Wisconsin legislature followed up in 1859 by declaring the act was without authority, void, and of no force. There are modern-day examples as well. The left has no problem using nullification when it suits their agenda. Look at the federal laws against marijuana. Several states have legalized marijuana, therefore nullifying the federal laws against it. Though I don't necessarily agree with legalizing marijuana, I agree that those states have the right to do it because nothing in the Constitution gives the federal government the authority to make using marijuana a crime. The left uses nullification against lawful edicts of the federal government as well. Look at all the so-called sanctuary cities for illegal aliens that nullify federal immigration laws. Those laws are legitimate because the federal government has been given the power to make uniform rules of naturalization, according to the Constitution. We need to remember and use the principle of interposition. I think nullification is a legitimate way for the states and even cities to stand in the gap. Our founders did. Unfortunately now, when states challenge federal overreach, what do they normally do? They sue. Can you see the problem with that? The entity that is violating the Constitution is asked to police itself from those violations. It's not going to happen. The states must pass resolutions to disregard or void federal laws or court rulings that clearly violate the Constitution. This shouldn't happen all the time, but should be done on serious issues where the national government is clearly in the wrong. Take the issue of abortion. We have been waiting 50 years for the courts to overturn that heinous ruling, and the Supreme Court finally overruled Roe v. Wade. However, the lower courts are already putting up roadblocks to the states making abortion illegal. What should have been done then, and we should still do now, is have our state legislators pass a law outlawing all abortions in our state. Then disregard the courts when they try to overrule those laws. We just tell them, the courts, that we are not going to comply with their unconstitutional rulings. That's our state's responsibility in order to protect unborn babies. That is, in essence, nullification. We should do this on other matters like homosexual marriage. The state of Tennessee has in our Constitution that a marriage is between one man and one woman. Why should the Supreme Court be able to overrule this perfectly legitimate principle? Marriage is clearly a state issue, not a federal one, so the court's ruling on them should not be enforced. The same goes for the laws protecting minors from gender-altering surgeries or prohibiting males from playing on girls' sports teams that the courts have already put on hold. The answer is to ignore the courts through additional resolutions of the General Assembly stating the reasons why the courts are wrong. By the way, all the above mentioned issues not only violate our Constitution, but more importantly, violate the law of our Creator. Remember, we are held responsible for maintaining His laws, and His laws trump any human laws or our Constitution. Unfortunately, our legislatures and governors have bought into the lie that the courts are the final say and simply comply with any outrageous rulings any court makes. You may say, wait a minute, doesn't the Constitution say that it is the supreme law of the land? How can a state have the authority to do this? Well, let's read Article 6, Clause 2. It says, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all the treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding. So, It's true that a legitimate federal law or part of the Constitution can negate a state law or constitution. However, the key word is legitimate. Notice it says laws made in pursuance thereof, meaning that if a federal law or court ruling violates the Constitution, it's not valid. That's the whole point of my argument. Also, as I've said many times before, court rulings are not law, so they don't fall under the above-mentioned clause. If the federal government or the courts overstep their bounds as stated in the Constitution, it is the right and the duty of the states to nullify their overreach. It's time to stop the tyranny of the courts and the overreach of the federal government. Interposition or nullification is a legitimate tool. If we don't use this principle, then more drastic measures like secession will be needed. For more detailed information on nullification, I recommend a book called Nullification: How to Resist Federal Tyranny in the 21st Century by Thomas Woods, Jr.